Hang on a second there. Okay, now, well, we was live, but now you guys hear me. Pro Se Lawsuit Center. Welcome to the show tonight, and we're going to talk about the credit card package. It's on sale right now, but I'm having a computer situation with that, and I can't pull it up. But I made the changes to it already. I'm going to post it in the link here. We're going to see if that whole thing comes through. Yep. And they marked it down to $50. And I upgraded it before I marked it down. Then I don't know what happened. It says I went to it too many times and I can't see it. I think it's up and running. So the credit card lawsuit package is been upgraded and marked down. Oh, where are you going to get that kind of firepower? Upgraded and marked down. And there was a few people that I promised the credit card package to that did a couple of things in the last couple of streams back or whatever. You guys send me a new video. I wasn't able to send it out because, well, it got infected. Well, no, easy. When you guys, if you invest in the program and you have trouble receiving your document or something, and I have to send it to you manually, so to speak, to your email address, so my email address, okay? Well, you should actually do this all the time. You should always copy and paste it into your own Word and save that original file clean. You should always do that, even if I don't send it to you from, that way you have the original files clean. And if you decide to help somebody else, you can whip that out and whatever, and they don't have to know that you've been through this. They just tell you've been coaching. So there was a holdup on getting it out there, everybody, because that file requires, well, it doesn't require, there's no coaching on it. It doesn't require any questions. And with the updates that are done to it right now, there's no, I don't know how there's going to be any coaching on it. Any coaching necessary. I'm going to make a little. Now, this package was fire before I updated it with some of the new stuff that we're using, the emergency constitutional situation thingy going on right there. And we're going to put it in right here. There. And not realize you could put that much words in there. It's been reduced down. I'm just gonna let you guys just check that out for a minute. What's up? What's up, C. Frederick? Yeah, I was going to show it, the credit card package tonight and the new product page and everything, but I don't know. It said I went to it too many times and and I needed to, to do some of my cookies, and I didn't have time to figure that out. Okay, but we are going somewhere tonight, I think, or that's the plan anyway. We're going somewhere tonight. Welcome to the show, and I'm glad you could make it. So the credit card package, and it's kind of funny how it goes because it's always been the least expensive, I think, so to speak, because, well, for a couple of reasons. Number one, people ain't got, you don't have, $1,000 to put into this credit card situation because most people just deal with that shit until they get to taking your money out of your bank account and shit, or garnishing your wages, which is actually, that's even worse. Well, either one of them is a situation. And so, and with the real time feedback from all from the people that been representing us or whatever for the period of time, we got this thing wrapped up to to there's no arguing. There's no arguing, and if there's no arguing, then that's okay. So that's most of the battle. Okay, if there's no arguing, and the reason is, try to keep it simple. When arguing starts, when it ends, then the attorney's buddy, the judge, gets to help, somebody. I'm not trying to sway anybody's judgment over here, but when the arguing's over, the judge gets to make the decision. The one that operates in administrative court from the rules that they made up at each location, the local rules. Okay, but this credit card thing, it's a situation, and it's pretty easy to get rid of. It's way easier to get rid of than the foreclosure stuff, whatever. And you know what? In my opinion, and I'm just gonna go here, YouTube, because this is my opinion. It's a lot easier to get rid of. It's a lot. Okay, let me change that. This credit card situation is a lot easier to have better success at challenging. Let me sip my hot tea so I can. It's a lot easier challenging, or whatever you have to do to it. Okay. Sometimes they have, YouTube have a hard time with the words I use, because I see the beginning and I see the end. In the beginning, we're challenging, the end, we're shutting it down. And then we just have to figure out what the hell we need to do in the middle. That's, but not everybody rolls like that, but I'm fine with challenging. Challenging the third-party debt collection situation You know what? I think what I'm going to do, I can't. It's a lot easier. Okay, let's see if we can do this. Hmm. I better do it this way. Okay, we're going to do it this way. Okay, so we had another game plan, but you know how it goes. It wasn't working out. I couldn't show from the website. So what I'm going to do is let's see if I can do this. Yeah, mm, no. Okay, so I think we're just I'm sharing right now the credit card lawsuit. I'm not sure if you guys can see that. I'm not that good at this part of this situation. I'm thinking you probably can only see. Okay, so this has 3 documents in it. This is the actual credit card offense lawsuit document, and then it comes with a demand to dismiss if there's something already filed, and it also has a counterclaim. Okay, yeah, it needs to do a little work with. Yeah, yeah, I need to do a little work with switching that around. It shows the thing, but when you click on it, it opens up something else. Then you're off over there in another place, and I've done that a couple of times. Didn't work out that good. But I think what I'm going to do is I'm just going to tell you guys about it. So, and this lawsuit, I upgraded it, and you can I got it at $10 million. Well, I'm just going to talk from the counterclaim. Okay, because the way we do things now, until someone else can tell somebody, anything different, going in with the counterclaim at the gate or anytime after the gate, because when you go in with the fraudulent concealment, you can use the counterclaim anytime. Don't let them bluff you. You tell them Coach Neighbor said, oh, hell no. No, with fraudulent concealment, you can use the counterclaim or do anything anytime, because fraudulent concealment is a legal doctrine that tolls the statute of limitations. Oh, that opens the door. And not only that, there's one other thing that I learned too last night while I was studying that's been total BS. I gotta be lying because my grandkids give me a hard time because sometimes when I start counting, I got the wrong finger up and stuff, Okay, but there's one other thing. You know what? For all this time, people have been getting their stuff dismissed because they failed to state a claim. Okay, failed to state a claim. If your stuff got dismissed by a magistrate judge because you failed to state a claim, that is it $75 or $50? I think it's, I don't know, one of those $2 packages for the magistrate judge on the website has what you need to address. Failure to state a claim. Oh, wait. That's bar member BS. I learned that yesterday after bar members BS. You don't have to connect all of that shit to each of these. Oh, thinking about it from that perspective, I wonder with the fraud thing, because the fraud thing, they got the same way. In order to state a claim of fraud, you got to do all of this. Running without limitations. I wonder if this fraud thing is the same way. Well, we passed the fraud anyway because we on the RICO. But you know what? It just failure to state a claim. If you got kicked out of court and you lost because of that, you should get that $50 pass. I think $75. I think it's $2 million, right? It's starting to have more and more value. All right. Around here, we sell the sizzle, not steak, because steaks burn. Steaks burn selling the sizzle. Oh, I can't wait to research that. But anyway, let's stay focused. When you bring your fraudulent concealment to the table, everything else is told because of statute of limitations. So, okay, so we're coming to the table with our $10 million claim for a violation of the Fair Debt Collection Act practice at 1692. Now, I don't use their stuff but this is an act, so that makes it a federal law. Breach of contract. That's the next check down to the simple. Check down to the simple. Fraudulent misrepresentation. Oh, and infliction of emotional distress. And don't forget your constitutional, your statement of constitutional emergency, which is a whole another thing. We haven't even got down to that yet. Okay. Breach of contract. Fraudulent misrepresentation. And so was there a contract? Just kidding, All right, but you know what? We start out under Haynes versus Kearns. The pro se litigants are to be held at a lesser standard and we just throw that in there because we like to do some punching. Okay. So the factual allegations, the contracts relying on personal trust, confidence, or credit may not be assigned they may not be assigned for collection without consent of without the plaintiff's consent and an assignment of alleged debt. Oh, you have to consent? Oh, how could they pass that? Oh, this isn't the factual allegations. This is the factual allegations section. Okay, the defendants violated the Fair Debt Collection Act practice, whatever, attempting to collect the debt without a valid contract. So if they're collecting a debt without a valid contract, is that breach of contract? Oh, wait, it had to be a contract. Well, there wasn't a contract, but they're still collecting with it. I don't know. I'm not that smart, but that's the way I see this shit. Okay, I don't know. A breach of contract. Oh, wait. Chain of title. They don't have proof of the chain of title. Or wait, let me see. There's proof of ownership. They have to provide all of that. Oh, wait. Okay, so we're not gonna. This is gonna take a week if I don't. Okay, so the alleged application was altered and missing essential disclosures. The alleged application for the credit card, it was missing, and the original creditor has no claim, and the attorneys are suing without standing. Without standing. They're suing without standing. They're trying to sue now that you got this, that you about to get this shit for $50. They're trying to sue without standing. Okay, so the affidavits that they file are defective, sworn only to belief, not personal knowledge, and are inadmissible. Read that shit. The affidavits that they use to that, they say is sworn to belief, not personal knowledge. Is there a difference? Oh, that's 4 more videos. Stay focused, coach. Okay, so the junk debt was bought for pennies on the dollar and resold to the attorneys who lack authority or a license. Oh, don't even get me started. The attorneys lack authority or a license. Okay, that's we just okay. The defendants, the debt collectors cannot show the original signed contract, complete chain of assignments, or any business records that would show that, they had a contract with anybody. The alleged account details are missing. The alleged account details are missing, making the suit, making their debt collection BS unenforceable. Okay, so if they're going to come after you, what? They don't have nothing. The date that how much was paid, how much was not paid, how much is owed. No, your ass didn't pay nothing. All right, sorry. Okay. Additional unauthorized fees were added, constituting false representation of a debt. Okay, come on, coach, what fees? Okay, so I already know in the foreclosure, they're charging y'all asses for the foreclosure shit, and they ain't even got to it because they're trying to chase you off the property with a bunch of bullshit and people come to your house and all that. So, yeah. That's my opinion. YouTube. To add these extra, and the plaintiff was harmed by the credit score, employment, housing, income, emotional well-being. Oh, wait. You're trying to get a house. You want to move to the nicest place so your kids can have, oh, wait, but maybe you can't move to where you want to because these attorneys started collecting debts that these companies did a charge off on. They did a charge off. YouTube, go, this is right. They did a damn charge off. Okay. Corporate businesses, when the debt's not collectible in a certain amount of time, they do a charge off. And I call it like a check down. The check down charge off. Okay. So, first of all, the credit card application, in my opinion, YouTube, was done the same way as the mortgage and the deed. Once you signed it, it was altered after your ass left the table or mailed it into them or however that shit took place for the credit card stuff. Okay. And then it was processed through the Federal Reserve for electronic credits. Now, I've been doing this for a long time, and it's illegal to loan credit. I mean, I don't know. I'm not that smart, but that's what I learned. And I learned that shit because, they try to charge my family with money laundering and wire fraud and interstate transportation and all that shit years ago, back when they was going after my ex. And I'm not that smart. But you know what? For all of that shit to be going down, there's got to be money. I told them. I called the FBI. I called Rob Schaefer over in Missouri. And I tell them, y'all find the money and we'll split that shit. But they ruin your credit. They jam the whole system is structured to jam you up. And make your ass have to be at work. So you'll take the check down. But you ain't got to do that no more. Okay, the first cause of action is a violation of Fair Debt Collection Act practice. You're the plaintiff is your consumer, and the alleged debt meets the definition of the FDCPA, and the defendants are debt collectors, and they put that shit right on all the emails, right on all the stuff they send you. But they're lying because they're collecting debt for their own ass. They're not collecting for the alleged whoever the other person is, the third party collector, the original debt. No, the defendants committed probated acts, and they included false representation and the amount of the legal status of the alleged debt they're attempting to collect without legal authority. That's the word. I'm not done. Additional unauthorized fees, failing to provide validation, and using defective affidavits. Okay, y'all need to just read that when you that just count one and breach of contract. Okay, no contract existed between the plaintiff and the defendants. No contract existed between any. The defendant cannot produce a signed original contract proof of assignment. They can't prove assignment that these people hired them to collect for them. Any attempt to collect is unlawful and a breach of the alleged contractual framework. It don't have to be okay. Not in my head where we roll without limitations. Okay, that's kind of where I'm at. Okay, count 3: fraudulent misrepresentation and concealment. Now we could have stretched that out, but it's kind of stretched out already because So fraudulent misrepresentation and concealment. Defendants were concealed that no original creditor had an interest. The defendants misrepresented the debt ownership amounts and the legal status. And the defendants used forged or altered applications and affidavits to deceive the plaintiff and the court. All right, they ain't deceived the court, all right, but just we need somebody to step up here, okay, and you going out to the court too, so but we just want to throw this in for the words to make. I mean, you can leave the court out if you want to. I like to throw it on there because it sounds good. The court don't know. Okay, count 4, infliction of emotional stress. Oh, the defendant's illegal actions cause severe anxiety, loss of sleep, health deterioration, and humiliation. And we could go on even longer with that. All right, and then then you get served, and all these people, and then your shit goes on internet, and everybody, your neighbors can pull up, loss of income, loss of business opportunities to move into the neighborhood you want to move into because your credit score took a dive because of all these lies. Oh, how that connects together. Okay, you lost the business opportunities. Well, baby, you couldn't get that loan that you needed because your credit score, your score of credit, peace of mind, due process. So we're just gonna $50. This lawsuit package right now for this weekend is $50. But you know what? It ain't free because I need two video reviews. One video review reviewing the power or whatever, the power or lack of power that when you get done reading it. Okay. And then I would like a second review on demand because I'm giving this away. Second video review with of how they react when you go to punch them in the face with this. Okay, that's how how long they gonna stand in the back room and talk about are they gonna try and make you take it back? Are they gonna pick at it and try to you see what I'm saying? Yeah. Those are the two things now. In the credit card, a lot of times people are forced to sign non-disclosure statement in the end. I need my two reviews before the end because I don't run attorney stuff where no. This is educational and punctual. Educational and punctual. Not punctual, punctual. Okay. I gotta work on I gotta work on that last one to bring in underneath the affliction of emotional distress and punctual. Yeah, okay. Give me a couple more days. So the damages. So the plaintiff requests compensatory and punitive damage. See, now I can't talk playing around. Compensatory and punitive damages exceeding $10 million for the legal expenses, mental anguish, loss of income, damage to credit score, embarrassment, humiliation, and emotional suffering. Period. Okay, sorry. The plaintiff requests punitive damages and sufficient to deter future misconduct. and then we go into the relief requested jointly and severely, and awarded compensatory damages, punitive damages, consequential damages, including credit harm and emotional distress, pre-judgment and post-judgment interest, attorney fees and legal costs where permitted by coach neighbors. Yeah, okay, sorry. And any other relief deemed just and proper. And and we're going in for a settlement conference. Okay. We're demanding settlement conference because everything that actually I put on there, settlement conference first / jury demand. Where the first time I told the lady in federal court that I wanted a settlement conference and there wasn't a place to mark settlement conference, she looked on there. She looked at me like, okay, look, you know what? I can do a check down / and right in here to what I want to have written down so everybody's happy. I'm figuring out a way to make everybody's happy, because if I can't figure out a way to make me happy before I leave, I'll try to make you happy. Then we're gonna have a situation later. So, settlement conference. Okay, so yeah, that was just the first document in the package. So there's like 3, and it doesn't require too much work on that. So I know everybody around Kansas City's probably had to watching the Chiefs get beat up, or at least the last I saw, they were getting beat up. So okay, thank you guys for the value of sharing your time. I'm gonna get out here and get a few more things done, and go find something to snack on.